Welcome, everyone. Today we're doing a deep dive into a really interesting property law matter, the Botes case.
That's right.
We've got an article here analyzing it, and it touches on some key issues. Liability for those hidden problems, latent defects, and how exemption clauses fit in.
Or perhaps how they don't always fit in.
Exactly. So our goal today is to unpack the Botes case, understand the legal principles, especially around these hidden defects in property deals.
Yes, it offers some, well, very important clarifications on sellers' duties, particularly developers.
Okay, let's start with the basics then. What exactly is a latent defect based on our source?
Well, the article explains it as a flaw, something you wouldn't spot during a normal, reasonable inspection of a property.
So not immediately obvious.
Not at all. And these are the kinds of things that often only show up, after the sale, causing potential headaches for the new owner.
And the Botes case itself provides a pretty serious example, doesn't it? It wasn't just a small issue.
No, definitely not. In this specific case, the defect was a timber roof truss. It had been installed improperly, dangerously close to the chimney, actually.
Creating a fire risk.
A significant fire risk, yes. And importantly, it was hidden, concealed, not something a typical buyer would just see.
Right. So the buyer, the plaintiff Knoetze, experienced a fire. And the argument was this hidden defect was the root cause.
That's precisely it. The claim was that the fire damage flowed directly from this undisclosed latent defect in the roof structure.
Okay. Now, many sale agreements have these things called exemption clauses. What's their usual purpose?
Well, exemption clauses are basically terms put into contracts to try and limit or even exclude one party's legal liability for certain problems.
So in property, a seller might use one to try and avoid responsibility for defects found later.
Correct. It's an attempt to say you buy the property as it stands, warts and all, so to speak. It's about allocating risk.
But as you hinted, they aren't always ironclad.
Definitely not. And the Botes case is a perfect illustration of their limits.
So in this case, the developer, the defendant, tried to use one, tried to rely on that clause.
They did, yes. They pointed to the exemption clause in the agreement, hoping it would shield them from liability for the fire damage.
But the court didn't see it that way.
No, the court ruled against the developer on this point. And the reason is crucial.
Which our article identifies as fraudulent non-disclosure. Can you break that down for us in this context?
Certainly. Fraudulent non-disclosure, when we talk about latent defects, means the seller knew about a serious defect.
Knew about it.
Yes, or was, at the very least, reckless about finding out. Especially a developer, someone with expertise, and they deliberately didn't tell the buyer.
So it implies intent or a kind of willful blindness?
Exactly. A deliberate or reckless hiding of important information that could affect the buyer's decision or the property's safety.
And proving that. Well, the article mentions expert testimony was key in the Botes case.
Absolutely critical. The plaintiff brought in experts who showed the roof truss installation wasn't just poor workmanship. It actually violated national building regulations. Standard construction practice was ignored.
Wow.
This evidence was vital. It helped establish that this wasn't some minor issue a developer might overlook. It was fundamental.
And demonstrated negligence, presumably?
Yes. The court reasoned that given the developer's role and presumed expertise in construction, they should have known about such a dangerous defect. Ignorance wasn't really an excuse here.
It really brings home that principle of fairness, doesn't it? Transparency in these big transactions.
Precisely. The court underscored the importance of good faith. You can't just hide behind an exemption clause if you've knowingly or recklessly failed to disclose a major problem like this.
It shifts the balance a bit. Buyers still need to do their homework, of course.
Of course, due diligence is always important.
But sellers, especially professional developers, can't actively conceal serious flaws.
That's the crux of it. The ruling made it clear that liability attached because the non-disclosure was considered deliberate or reckless, and it directly caused the plaintiff's damages.
The fire wouldn't have happened without that specific defect being hidden.
That was the finding. The link between the failure to disclose and the resulting harm was established.
So the big takeaway here seems to be, developers have a clear duty. If they know about significant latent defects, particularly ones affecting safety or usability, they must disclose them. An exemption clause won't save them if they breach that duty.
That sums it up well. It's a significant point for consumer protection in the property market. Buyers need that assurance of honesty about known serious issues.
It certainly seems the Botes case stands as a really important precedent then. It puts clear limits on how effective exemption clauses can be when serious defects are knowingly hidden by developers.
It really does reinforce that duty to disclose.
Which leaves us with a final thought, perhaps for you listening. Considering this Botes ruling, what are the ethical considerations and the practical steps for both developers and buyers to ensure real transparency and deal with potential hidden defects before a sale goes through? Something to ponder.